we're here for some motion hearings. Very exciting. As they mess with the camera. We've got nice little like sconce there and a different sconce there. Interesting little detailing under it. A little relief carved into the side of the wood. It's pretty. Oh, no. Now we've got ourselves, what are we going to focus on? Back on the seal. It's a little blurry there. There we go. The Great Seal of the state of Florida. Exciting. The Great Seal of the state of Florida apparently features what I assume is a palm tree. Looks like maybe a cutter ship. Although I see what looks like a wheel on one of them. So I think there might be a cutter ship. Or maybe it's just some sort of, it's combination sailboat, maybe with a wheelboat. And then there's like a little dinghy there. And then we've got a woman with some flowers. Is this meant to depict the finding of the Fountain of Youth? Is that what this is supposed to be? Because that would make some sense. And she's got some sort of white flowers in her hand and also like interspersed in the scene. And some sort of bush in the front there. Not sure exactly what kind of bush that is, but apparently it's a very Floridian bush. Also, we've got the sunrise, I'm assuming, on the horizon. Yeah. Okay, I think the steamboat is behind the other boat. It's a little hard to tell from this angle. But I think there's 3 boats. Is that even a boat in the background there? I mean, well, it looks like there's smoke coming out of a smokestack. I think it's a wheel. So I think that's a boat maybe back there. So I think it's like some sort of sailing ship, cutter ship, a dinghy, and maybe a wheelboat behind them. Or maybe it's just a water wheel and it's industry. Also, I can't help noticing that these sort of white flowers that she's got are sort of almost in a vertical line, which I'm not really sure what that's going on there in terms of the aesthetic. So if we look over here in sort of the bottom left corner, we've got what looks like a bush full of these white flowers. And then there's just a string of the flowers, and she's holding some of the flowers. I'm not sure what's going on. Sarah Boone sitting at council's table today. She has not been relegated to the jury box today. How exciting for her. She gets to sit at defense table. How nice. How nice. She's definitely got the chains on though. The haircut, I'm not sure is doing her any favors, to be honest. I kind of like these lights that are hanging from the ceiling. I wonder if it would be possible to turn off the recessed lights in the ceiling and there still be enough light, because I feel like the recessed lights are detracting from the beauty of these pendant lights. I feel like there's got to be enough light between the pendant lights and the lights coming in from the window. It's like, do we really need the recessed lights on as well? Because I'm not feeling the juxtaposition of these relatively beautiful pendant lights with these cheap ass, normal looking, everyday office bullshit recessed lights. I'm not enjoying those. I'm not enjoying both those architectural features. So if I were the judge in this courtroom, I'd be asking myself right about now, is it possible for me to just turn off the recessed lights, because the recessed lights are some bullshit? That's my problem right now. There are palmettos on the seal. Florida can't have palmettos on their seal. That's South Carolina's thing. Get your own thing, Florida. Get your own thing. Get your own goddamn tree. Fuck you and stealing South Carolina's tree. That's some bullshit. Get your own damn tree. South Carolina seal has a front and back. It's got that going for it. South Carolina will fight you, Florida. Don't try us. Don't try us. We started a conflict between the states before, and goddamn it, we'll do it again. Get your tree off of your flag. War Between the States, Part 2, Palmetto Edition. It was designated their state tree in 1953. That's some bullshit, man. Look at this bullshit recessed light action. Look at these air vent and these recessed lights, man. There is no joy or love in those whatsoever. In those recessed lights compared to the pendant lights. Why would you obscure the relative beauty of those nice pendant lights with these bullshit everyday, I found them at Home Depot for $5 each, recessed lights? This is some bullshit. Do you think they look like solar tubes, skylights? Not to me, they don't. They don't look anything like that. They look to me like bullshit, recessed, everyday, discount special, Home Depot, get four for the price of 5, or whatever the other way of expressing that is. Bullshit, everyday, recessed lights. They don't look like solar anything. They look like some bullshit. Now I've got a big black nothing. I don't need to know about Live View, and I don't need to know about REM 10 LNC CH04. I'm not sure what REM 10 LNC CH04 is, but it's none of the things I'm interested in. And I also don't care about Live View. The big black nothing is doing nothing for Uncivil right now. The big black nothing is representative of the blackness in my heart, but not much else. Now I've got some, oh yeah, there we go. Thank God. Did Florida really put their state seal on their flag? That is some bullshit. That is you don't put your seal on your flag. Flags are not bed sheets, man. Don't do that. If you have to write the words "the state of Florida" on your flag has failed. Your flag is a bad flag, sir. It has failed in its fundamental flag tasks.
Any other appearances on behalf of Mr. Beck? Good afternoon, sir.
Kevin Beck on behalf. Good afternoon.
Okay, I've got closed captions, but no audio.
Thank you. I'm going to moot Messrs. Beck and Henderson for the moment. We seem to be getting some
I've got
feedback.
audio. It says I've got audio in one ear, but I can't hear anything.
We can address that if and when that's necessary.
Can you guys hear? I can't hear anything.
This afternoon on a litany of hearings, the court did receive the
Why can I not hear
motion
anything?
to return property, which just filed yesterday, and the state's amended notice or amended motion to strike the amended notice of battered spouse defense. The court was
Okay.
reviewing the
Why do I have no
therein, which is why
output?
we're a
Oh.
few minutes late this afternoon. Are
Hold
there
on.
any housekeeping matters, state, that we need to address before we begin this afternoon?
Not from the state.
All right, any housekeeping matters? from
I've
your
never had
side
that
of the-
particular problem before. Oh,
Okay. To the extent we may be hearing from Ms. Boone, ma'am, if you could, please raise your right hand. Madam Clerk's going to go ahead and say.
okay. I've got mono. I've got mono audio. Holy shit.
I believe that the first thing that was filed in this case, just as a matter of time, was.
All right, we're gonna have to mix it. We're gonna have to mix it down.
Excuse me, the defendant's motion.
We're gonna have to
for
mix it
statement of
down.
particulars that was filed on
There we go.
September 2.
Now
I
you've got
reviewed
two-channel mono. That's better.
You may proceed, sir.
Now at least you have two-channel mono.
Judge, do you want me at the podium?
However you feel most comfortable, sir, but because we have your co-counsel appearing virtually, I would ask that you
Someone
direct
remind me to turn that off before we're done.
into the microphone so that they might be able to hear it, sir.
Judge, as you know, I filed on behalf of Sarah Boone this motion for statement of particulars. And in my motion, I quoted the language in the information that she was charged with. And the pertinent part charges Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violated statute 782.04, paragraph 2, by an act eminently dangerous to another and evincing a depraved mind regardless of human life, did kill Jorge Torres. Judge, that's about as bare bones of an information as you can file in a case. I know
Fair.
anytime there is a weapon used, it's usually shot with a firearm that was used, that type of language. That is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. One, the victim is dead. Two, the death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of Mr. Torres.
Fair.
This is a unique case, Judge. It does not involve a firearm, which I believe many of these cases do. I'm sure you're well aware, the state's well aware, the defense is well aware of the report, the videotapes in this case, and the overall general facts about the suitcase and Mr. Torres being in the suitcase asking to be let out by Ms. Boone. But the state, in their charging document, has failed to say exactly what it is that they believe is the...
I like the very, very low rent signs here at the clerk's desk. It's just the most low rent thing possible. Just 2 sheets of paper in a sheet protector. And it just says in large type, please do not approach the clerk. and it's just a regular sheet of paper inside a sheet protector that's been pinned to this fairly nice wooden desk in the most cheap look possible. Holy shit, dude. Holy shit, dude. That's like, can we upgrade our game a little bit? Damn. Pressing on.
Criminal act that caused the death by Sarah Boone. Some information that the defense could receive.
One will take note, for example, that the judge's placard indicating who he is not a sheet of paper that is just put in a protector that's just pinned to the bench.
From them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose. None of that language is in the information that would let us know what it is they're claiming that she did or series of acts that she committed that constituted the cause of the death of Mr. Torres.
I'm liking this argument. I'm liking this argument way more than I expected.
Explain that an act is eminently dangerous to another or demonstrating.
Now, I like this argument technically. I like this argument technically a lot better than I thought I would. I feel like the answer to this is just going to be too little too late, right? This should have been done literally years ago because this case has been going on for 4 years. So assuming they had a right to this should have been done many, many moons ago. And it's just probably procedurally defaulted at this point, I imagine, is the answer to this question. But on the merits of it, I like the argument more than I thought. It's like, you know, he's got some points. He's definitely lawyering. I'll give him that.
A depraved mind if it is an act or series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury? 2, is done with ill will, hatred, spite, or evil intent. What acts or actions by the defendant did they present or will they intend on presenting in the trial that would tend to indicate that she had ill will, hatred, spite, or evil intent towards Mr. Torres? And 3, is of such a nature that the act itself indicates an indifference to human life. Again, some explanation that give the defense, my understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial.
I'll tell you right now, if I had represented her, it wouldn't have occurred to me to file a bill of particulars. So he's probably a better criminal lawyer than me. Although that being the case, it would have probably occurred to me, you know, if I were earlier in the case. But 4 years in, it would not have occurred to me to file a bill of particulars. So, you know, fair enough. He's doing a good job.
And ensure that the defendant's rights are protected.
The judge is going to say no, but I think he's doing a good job.
Shall, in plain, concise, and definite written statement of the essential facts constituting the offense charged. In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Not bad. Not bad. Clean, to the point. I also like the way it was presented, I have to say. I like the way it was presented. It was clean, simple, and didn't overextend its welcome. It was a relatively concise argument without being repetitive. It got in, got what you need to get, got all the pertinent detail, and got out. It was a well-argued motion. Very good job. I like it. Good job.
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, P-A-J-O-N, 374 Southern 2nd, 1070, Florida 3rd DCA 1979, and Sutherland versus State 305 Southern 3rd 776, Florida 1st DCA 2020.
Can I have the second citation again? 305 Southern 2nd.
Southern 3rd 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is the position that it's an extraordinary remedy to be given a statement of particulars in a case. The
He's not
information
wrong.
in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There is no element of surprise. The state of Florida has provided discovery to the defendant in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in a trial, exactly which of the witnesses we've disclosed will be called at trial. And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the suitcase begging to be left out. And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position that they have not.
I don't know about that, but
stated
it's mens
why
rea for something.
a statement of particulars is necessary. It's an extraordinary remedy. They have all the discovery. Not only do they have all the discovery, they have the narrowed down list specifically as to what will be introduced, and they are clearly on notice of what constitutes the acts and the mens rea, because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars. There are cases where, for example, somebody commits multiple acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back, and it's unclear as to what the state is talking about. If counts 1, 2, and 3 all say battery on X day, there are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to February 23rd, 2020. The metadata on the 2 videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020. Given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars.
Yep, that sounds about right.
Any response?
Yeah, that's sort of like kind of very similar to what I was saying. Like, even assuming that this would have been proper 4 years ago, a lot has happened since then. It's like, we're not sure what you're talking about. It's like, really? You're not sure at this point what we're talking about? 4 years later, you're not sure what we're talking about? I think we know what we're talking about. So yeah, this motion, assuming it was ever good, is basically procedurally defaulted at this point. It's like, yeah. Yeah, but I liked his argument better than I thought it was. So points to the defense. I thought it was better than I was expecting.
My understanding of the law is the court has broad discretion on this issue about whether to require the state attorney's office to give more particulars about the offense. And this is somewhat of a unique case. And the state attorney just mentioned where there was prior incidences of violence or battery that occurred prior maybe to the death, and whether or not that was relevant or admissible. That's the case we have here. Judge, I'm sure you're aware that Mr. Torres suffered from some blunt force trauma that was unrelated to the death. The medical examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torres's body that did not cause the death, that was unrelated to the cause of death. And that information has not been detailed whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torres's death. And if not, if we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information is...
But is there anything that's missing under the statute? I understand your reliance on the jury instructions, but what's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
Well, I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute, and at no time a court would ever order a motion for statement of particulars.
But the date's there, the time's there, where it happened is there, the underlying charge is there.
I understand, and I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law, based on the unique set of facts, that a court feels compelled, yeah, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts that I think there are.
If the issue is discretion, then the reviewing standard is abuse of discretion, which means you lose. The defense loses, right? So abuse of discretion, like, yes, technically the judge, so you have like mistake of law, which is, you know, the judge can't do this because it's illegal, versus abuse of discretion. Technically the judge can do it, but they really shouldn't have. And abuse of discretion is really, really difficult argument. So motion denied.
There are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know whether it was environmental or not. He gives two explanations. So there's a real question about that. And of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior, and what exactly they're claiming that she did that constitute. Is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video. There was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to, there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was necessary. Okay. Thank you.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776, and relying on State v. Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it, the greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
Thank you.
Pretty logical.
Moving now to, give me a moment, and I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes. Thank you, sir.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery, specifically the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before any interrogation. Now, the argument by the state is well taken.
Okay.
The defense does have a duty to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th. And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020. And the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room.
Yeah. That happens every day. That happens literally every single day. The police sometimes, well, of course, sometimes they bring you down to the station. Sometimes they invite you down. And, it's like, hey, we just have a few clarifying questions, don't you know? Just a few clarifying questions, just some simple clarifying questions. Would you mind swinging down to the office and answering a few questions for us? Yeah, that happens literally every single day. No, you can't. No, you can't. Right.
Room, and I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were. I believe
they wouldn't have to be read. They wouldn't have to be read because she wouldn't be in custody. It's non-custodial. If she came down believing that they were just asking a few questions, as long as she had the ability to leave, there would no Miranda. Okay. All right, fine.
Some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority.
Could not leave, or it felt like she couldn't leave? And did she really not have the ability to leave? I bet she did. I bet all she had to do is get up and walk out the door. That's not coercion.
Based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly, and she left out the main question at the end.
Whether or not you believe, whether or not you understand. Is the main question the question, do you understand the rights as I've read them to you? Yeah, that's not actually required by Miranda. They just have to read you your rights. They don't necessarily have to confirm that you understand it. So some cops will say, do you understand the rights I've read to you? And sometimes they don't. I know no case that requires it. I mean, there might be some jurisdiction somewhere that requires it, but to the best of my knowledge, well, it's not required by the Supreme Court, at least. You don't have to ask them whether or not they understand. You just have to give them to them.
Make sure it's verified before you file in good faith a motion to suppress her statements. Well, the state attorney has tremendous power.
Yes, they do.
I've made this request, what was it, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information.
Yep.
The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September.
You have to make a knowing voluntary waiver. Yes, you do, but the cops don't necessarily have to confirm that by the question, and even the question doesn't necessarily confirm it. So, like, it has to be knowing, intelligent, and voluntary waiver, but that's pretty easy to meet legally. So, yes, the waiver does have to be knowing, intelligent, and voluntary, but there's no duty for them to ask, and even if they do, that doesn't necessarily prove it. So, you're partially right.
September 3rd to continue the case. We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the two detectives, the two homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Response.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months.
Fair point. Fair point.
Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly.
True.
What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing. What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been...
Yeah, fair point. Like, I think he's right. I'm certainly not aware of any case law that speaks to if the cops violate their policies, that gives an issue, right? Miranda is a constitutional right. It's a matter of law, not a matter of policy. So the cops may do it a certain way. They may not do it a certain way. They may read it from a card. They may not read it from a card. They may ask, do you understand? They may ask, do you not understand? They may get this thing. They may ask the person to sign on the bottom line. They may not ask the person to sign, right? They may read the person the rights as they're being arrested. They may delay reading the rights until they're being questioned, right? So there's a bunch of different ways they can go about it. And they may have a policy of doing it some way or another, but that doesn't give you a basis of constitutional protection, and Miranda is by its nature constitutional. So unless you can point to a legal violation, the policy violation is neither here nor there. So, can you point to a violation of law, right? Can you show in the tapes where there was a violation of law? And the answer is no. So their policies are like, yeah, it doesn't get you anywhere, because even if they violate their policies, it doesn't matter as long as they follow the law. And you have the tape, and you have everything you need to determine that. So the policies aren't going to help you. I tend to agree.
And absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law relief could be granted under the law. And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial, because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either. So it's our position that their request should be denied, primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases, said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then? Assuming you're correct, and assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here, because I haven't watched the video. I'm not asking you to play it.
I probably should have.
But I need a little bit more context as to these statements, because I have unfortunately no frame of reference.
But she says Number one, the date of this event, they seized her phone at the scene.
Okay.
She was told that they were going to bring her phone back to her, back at her apartment, the very next afternoon.
Okay.
The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone?
Yep.
Sarah Boone got there and saw that there was a desk or a place there to retrieve the items, and she saw the male detective and said, is this where I go to get the phone? He said, no, we got it back here in this room. Come back here in this room and we'll get it.
They deceived her. Deception is not coercion, man.
Now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, look, we got the autopsy back from the medical examiner. We've got to talk.
So in other words, they tricked her. The police are able to trick people. That's been pretty well established. The police are able to trick you about facts. They can't trick you about law, but they can trick you about facts. So, oh, I'm pregnant, not feeling well. Is that a lie? Could be. It's not illegal. It's not a legal statement. It's a factual statement. Oh, we have the phone back here. This is where you come to get them. Okay. Yeah, they tricked her. Police are allowed to use trickery. That's been well established many, many times. So sorry, no fraud in the deception, no fraud in the inducement for you. Not working.
To you about that. 2 times she said, we must, I don't think it's must, we've got to talk.
Deception is not coercion.
She goes, okay. So I got to read you these Miranda rights again. And again, she had.
And they read her Miranda rights again, which may or may not strictly be necessary. They may or may not be required to read them multiple times, but you can't fault them for reading them again. Like, it's not bad to read them multiple times. Right? So whether or not they had to at that point read them again, or even at all, incidentally, I don't even know that they had to read them at all at that point because they brought her in of her own free will. So I'm not even sure they had to read Miranda. So first of all, I don't think they had to read Miranda. Second of all, if they had read them before, I'm not sure they had to read them again. But the police apparently decided to read them again, being very, very safe, I guess, which is their prerogative. They're allowed to give you more than what the Constitution requires. So they apparently read them to you again, just in case there was any confusion. Not that I think you were entitled to it and you want to complain about the deception. Yeah, no, just absolutely no.
Read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy.
Thank you, Gemma, for becoming an uncivilian. Do appreciate everyone who hits that join button.
So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone, I believe it was the female detective and the male detective, and she was read Miranda rights, again, incorrectly.
How incorrectly?
So now the next day she's
okay,
back.
what is the nature of the incorrect? Right? That's the critical part of the legal analysis. When you say they were read incorrectly, in what way were they read incorrectly? Right? So like they don't necessarily have to follow a particular word choice, right? They just have to include all the substantive elements. So did they leave out one of the substantive things? Because then it might be a defective Miranda reading, right? If they failed to, for example, tell her that she could discontinue the interview at any time, right? And they left that out, then that might be a defective Miranda reading. But if they used like different words to express the same concept, then it's fine. So in what way did they misread them? You're just saying, oh, they made a mistake. What was the nature of the mistake?
In the interrogation room with the 2 deputies, the 2 detectives, and the lead detective says, we've got to talk.
Yes, we're behind law and crime because I've decided, at least for today's video, to pause when most of the time I'm speaking, because people don't like it necessarily when I speak over the court. So I'm trying to be a better streamer and not speak as much over the court. So yes, we're a little behind because, well, we were live and now we're behind by 9 minutes because I've had 9 minutes worth of commentary. So that's how that works. Yes.
About this autopsy.
Roll the tapes. They said the red are the full rights. Yeah. Okay. But then the question, all right, well, all right. See, here's the thing. The defense says they misread them. So even if I watched the tape, I'm not sure necessarily I would necessarily catch what the defense means. Like, I know what it's supposed to sound like in my head, but did they slip a word that doesn't really matter? So even if I watched them, right, I'd be like, that seems like the Miranda rights. I still wouldn't know what the defense is talking about. So watching the tape would only partially help me. It's like, is it written some way on the card and they slipped a word, right? They used the wrong word. And do I care? So without knowing what the defense is talking about, watching them read Miranda will be of little help to me. The best I could do is tell you, oh, that looks legally sufficient. But without knowing what the defense is talking about, I can't mock them accordingly. And the defense isn't telling me what they're talking about, so it's frustrating.
Giving her the impression that's what they were going to talk about. But I've got to read you these Miranda rights. And she said something.
They may or may not read it off a card. Reading it off a card is not legally required. It is not required to read it off a card. Many times they do because they don't want to, make a mistake, but it's not required. And it's not required. It's a nice thing to have. And if it's written one way on the card and they said it a different way, I'd want to know what the difference is and whether or not I care, which the answer is probably no. But these, yeah.
And Sarah said protocol because they had told her in the first Miranda rights.
Here's the Miranda warning, right? It's like I can do it off the top of my head. It doesn't necessarily have to be word perfect, right? You are under arrest. You have the right to remain silent. Anything you say can and may be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you at the government's expense. You have a right to discontinue questioning at any time. Would you like to continue knowing the rights I have? Read for you. Great. Moving on.
That this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk. You have to talk to us. We've got the autopsy.
The only way I could do it any better would be like to wrap it. That'd be good.
In addition, then she starts in the Miranda judge, she made a mistake on it. I don't know if it's an anonymous mistake, but
what's the mistake?
Statement, she said, I read the rights verbatim. The constitutional Miranda rights, I read to her verbatim. That is not true.
What was the mistake? Tell me the mistake.
We have it on audio. Fortunately, we have it on video.
What is the mistake? Tell me the mistake.
About whether that statement,
God damn it,
2-hour interrogation is admissible in this trial. That's what I'm going to show the court.
Tell me the mistake.
Policy, just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if they...
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're telling...
That's in the probable cause statement.
Okay, that it was read verbatim. Okay,
yes,
excuse me.
Formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is it was read verbatim.
That's correct.
Now, you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue? I think that's a simple constitutional issue, right?
Yes.
If there's a case law that buttresses that position, and that de facto is a violation of the Constitution, ergo, that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show that she actually omitted the last question. Okay? So the Miranda
Which is what? Do you understand the rights that I've read to you? That's like, what is the question? Because Miranda rights, I don't even think the Supreme Court require there to be a question. I don't even think you're required to say, do you understand the rights? Or would you like to talk to me? I think strictly speaking, they're just statements. I'm not even, I could go back to Miranda, but I don't believe there's a question in there. It's like all you have to do is tell them things. And then so there might be a question they left off. It's not a constitutional violation.
Is there for a reason. I don't know if they have them in the interrogation room or every deputy or homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you've got to get the waiver. There's 2 questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I
No.
believe so. Along
That doesn't
with
answer
her
my
other 2
question.
statements.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress.
What is the case law that says it's a constitutional violation? I'm not ready for that. And right about now is the time the judge stopped listening. Yep.
And I'll supply you with the case law, but I'm not ready for
There
that.
is
But
none.
The reason I wanted the policy
It doesn't
to answer your
exist.
question is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy. Those type statements are improper, that they're used to coerce somebody to talk. And I understand the detective. They had these videos, the 2-minute video and the short.
You can't make any statements prior to Miranda? According to whom? Yes, you can. You can make lots of statements prior to Miranda. I mean, there's limits. There are certain things you can't say. Like, for example, you can't say, if you don't talk to us, we will take away your kids, and then read the Miranda. You can't say that. But short of them saying something that's either legally erroneous or it shocks the conscience of the court because it's such a strong statement. For example, if you don't talk to us, we'll take away your kids would be an example. That would be the kind of example of things that will shock the conscience. So short of it being a legal fail in terms of they misstate the law, or it's a statement that shocks the conscience of the court, why can't they make statements before Miranda? That would be really dumb. That doesn't make any sense to me. Uncivil does not understand. Uncivil does not understand these interesting and novel legal arguments. They don't make sense to me.
Second video, and they had found it on her phone. So the homicide detective was chewing at the bit. To
Okay.
get her to talk. So she was
I'm sure she
trying to
was.
induce or influence her to speak to them and to not exercise.
Okay. That's fine. Your argument is the detective really wanted to talk to Sarah Boone about the incriminating video. Okay. I take judicial notice. I believe you're correct. I believe that they really wanted to talk to him. They tried to induce you. They're allowed to induce you. They can't coerce you. There's a very strong legal difference between inducement and coercion. I mean, not to put too fine a point on it, but like, inducement exists all the time in everyday life, right? To induce you to do a thing is just to make it more attractive. Every time you go to the store, there are things on the shelf. They're trying to induce you to buy things. I know this is a shocker. They're trying to induce you to buy things. And sometimes they put on sales and they'll say like sale, 40% off. They're trying to induce you to buy more. Wow, right? So yeah, can the cops induce you? Sure, no problem. They just can't coerce you. Okay, that's fine.
Exercise a fundamental right not to speak to them without a lawyer being present. So she made those two statements preliminarily that I believe the policy is going to say you don't do.
Uh-huh. And even if the policy said it, I don't care.
No, sir.
Like, even if the policy said it, I still don't care. And incidentally, like, I'm not sure what the real world equivalent of this would be, but I still might not care in the real world. Like, what would be the equivalent? I don't know. Some store has some policy somewhere that they didn't follow. Does it mean necessarily that your purchase was illegal? No. Right? It's like they didn't follow their own policy, but unless it somehow impacts the contract, right? Then it's like, I don't know. What they're allowed, they don't have to follow their policies. They just have to not break the law, which is not the same thing.
Just, the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in the court.
There you go.
The Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's piece
And
of
also the
paper.
U.S. Supreme Court
It's
does.
available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately, the state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the sheriff's office's policy, so these statements are clearly admissible.
Yeah, that's definitely not a thing, right? I do appreciate the mockery of it. By pointing out how silly it is, right? There's like, oh, they didn't follow the policies. That's the violation. It's like, really? That's the violation. So if we flip this on the head, yeah, they followed the policies, but they violated the Constitution. But they followed the policies, so it makes it totally admissible, don't you know? See, it doesn't make any sense. The policies are not the thing that control. The Constitution's the thing that controls. Damn it.
And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case.
And by the way, the reason they're making that distinction is there is some, we don't really have to get into the finer points of it, but there are some situations in which a statement might not be admissible and it can be suppressed for the purposes of liability, but it could be brought in for the purposes of impeachment. And so they're making this distinction. Like the state can't offer it in the first instance for liability, but if you get on the stand and say something inconsistent, then they might be able to offer it for the purposes of impeachment because it's an inconsistent statement. So even if the motion to suppress were granted, it might only extend as far as liability rather than credibility, which is a distinction that the jury doesn't care about, but at least the lawyers pretend to.
Law, they can come in if those statements are admissible and argue to the jury they violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? Doesn't matter what the policy is, doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or an impeachment.
Okay, thank you. All right, thank you both for your arguments and your positions. In reviewing the authority provided by the state, which the defense has conceded is taken in, is what it is. I think State versus Wright is the guiding light for the court here, 803 Southern 2nd, 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright.
Uncivil agrees. Next.
Moving now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are not asking to participate in this hearing. And we did confirmed that earlier this week. Similar to the other motions that we've heard today, I have reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are 3 motions. I don't know if you got the third one.
Are you referring to the motion to return property?
No, relating to cost. Relating to cost.
Don't know that I have. I'm just going by what the notice of hearing reflected. So no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll
that I
have to
got it
ask
yet.
Margaret. I don't know.
Okay.
But I filed a second amended notice of hearing. Can I give
Please.
you my copy?
And Mr. J, have you seen that, sir?
State doesn't really have a dog in the fight with the expert appointments.
Understood. Thank you.
Judge, what I had done
Don't
was
see
I
a date
had,
on here, Counselor. When was this sent? The certificate of services contains no date.
That's good. That's just sloppy. That's just sloppy. I have to say that's sloppy. Judge's like, I'm not sure if I have it. Would you like to see my copy? Sure would. That'd be fine, Counselor. Can I borrow your copy? That'd be fine. Yeah, this has no certificate of service on it. That's great. That's just great.
Okay.
this morning.
Okay.
You're not putting yourself in the greatest posture with like stuff like that. Like, I don't have it. Can I borrow your copy? Oh, this copy doesn't say when it was. Okay. Not a great start.
All right, what is the other motion related to cost, sir?
Well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's nunc-pro-tunc. I'd like it to be retroactive.
Ooh,
I actually had to hire them.
fancy.
As you know, I came on the case late, August the 30th.
That's correct.
And then I asked Dr. Harper to go down and see Sarah Boone. Dr. Harper lives in Okaloosa County, and she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file.
Nunc-pro-tunc is now for then. It's typically used only for clerical stuff. It's basically it's a phrase that's typically used to correct a past filing as though it was always that way. It's a way to go back into the past and change something retroactively. But it's typically only used for like clerical errors or like other things like that. Not, I'd like to have an expert witness. Like retroactively? Okay. I'm not sure how nunc-pro-tunc is used in this situation, but okay, that's odd. Fine.
The notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her, and she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr. Berkland. Dr. Michael Berkland is a crime scene reconstructionist and death investigator, and I'm asking for the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper, again, to be retroactively to the time I asked him to be in work on the case. And then the last...
When was that You're asking Nunc Pro Tunc to win on that, also to the August 30th date of your
Yes.
notice of appearance?
If possible, yes. That's when I officially got on the case.
Are you trying to retroactively file a motion now?
The third motion for cost, I don't have a copy of that, unfortunately.
Can I approach?
Yes, please.
Are you trying to retroactively file motions now?
Judge, I mentioned this expert, Dr. Michael Brannon, in that hearing that I think we had on September the 3rd. He's a clinical psychologist. If you'll recall, I had mentioned him. He had served as an expert in the Marsha Thompson Palm Beach County case.
I recall.
And so, as you know, he serves a different role as a clinical psychologist. Dr. Harper is serving as a forensic psychologist. And
Do you know what JACS's opinion with regard to the motion to appoint clinical psychologist? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other two motions regarding Dr. Harper and Dr. Birkeland, and it doesn't address Dr. Brannon, and notably JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other two.
The only request in this area that the state is going to make of the court is to, under its discretion, under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st. These two other people, I have absolutely no idea what they are going to say, and we would, I'll file a written motion and a proposed order and send it to opposing counsel. But that's what the state's request is going to be on the other two experts.
Yeah, I don't know if I'm going to have an objection to a written report or not. I may, but I'd like to see what the motion says
Sure.
before
And
I make a
I'm not-
decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
Is that in person or is that virtual?
Central?
Is that in person or is that virtual?
I believe
Okay.
the state's flying in, and I'm going to be there, Judge. That's the county over from me, Santa Rosa County, so about an hour drive for me, so I'll be there in person. We're going to have probably Kevin Beck that's going to appear by Zoom.
All right, so here's what we're going to do. JACS has provided their response, and their response was not appended to the motions that were filed because that was prior to the amended motion seeking indigence costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, nunc-pro-tunc those costs to August 30, 2024. And with regard to the other motion, the motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berglund, nunc-pro-tunc, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let's check real quick, Judge.
Sure.
Give me a minute.
Yeah, you're good.
Well, you're getting your experts, which is nice. Hopefully some of them can help you.
Excuse me? No, Dr. Michael Brannon. It had to be filed.
I'm not surprised they're granted. Maybe slightly.
While you're waiting on that, I
Right.
do see on your second amended notice of hearing, you also requested the amended motion for declaration of indigency and payments of due process costs.
It might be slightly weird if the judge denied it, though, because the notice for the battered spouse was only due for 30 days. So it'd be a little bit odd for the judge to say no on the time frame. It's happening very fast, though. It's like getting expert appointed, up to run, and ready to basically testify in 2 weeks. That's a tight time frame, but okay.
Also be heard. When was that motion filed as well, Mr. Owens?
It was filed just prior to filing these amended ones.
Were the-
It had to be filed prior to my motions for appointment of these experts.
Give me a second. Okay, so the motion to appoint the clinical psychologist regarding Dr. Brannon, was filed yesterday. The amended motions regarding Dr. Birkeland, an amended motion regarding Dr. Harper were filed yesterday, as was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and payment of due process costs is granted. The amended motions regarding Dr. Berglund and Dr. Harper are also granted, nunc pro tunc, to August 30. With regard to the motion to appoint clinical psychologist, filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon, and maybe we'll be able to address that. It may be a similar vein as to the prior response that JACS had provided. Moving now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
Judge, I believe the state's response is well taken, and I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone. So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any?
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't, but I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go and work with the law enforcement team and get in another imaging if they are not satisfied with the imaging that has been provided.
Mr. Cacciatore, good afternoon, sir. Can you hear us? And if you can you announce your presence for the record, please?
There has not previously been a forensic exam of that.
When the judge says, announce your presence for the record, you're supposed to say your name. Also, your mic is horrible. It may cause my ears to bleed.
Phone by a previous defense counsel.
Okay. All right. Thank you very much, sir. There was a John Sawicki that was appointed back in, not appointed, authorized back in 2020 as to electronic evidence. So I'm going to deny the motion for return of property based on the citations contained in the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm gonna do my best. We got about 18 days.
I'll cite to the parties for their own benefit. There were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs. It was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert. And there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
Judge, I wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about argument.
One witness for one attorney. Yeah, that's typical. That's a very standard rule. Typically, you only have one attorney for one witness. I always learned it at law school with the phrase "one horse, one rider," which I always liked. So for any given witness, there can only be one attorney that questions them or does objections with respect to them. One horse, one rider. I always like that phrase.
Okay.
He's arguing that one motion that they filed this afternoon, that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. Okay. I'm going to respond to the ones that were filed prior to today.
All right. I'll allow it. All right. Go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance, and Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I had filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed, after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert, and we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing, I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday, I spoke with her on the phone and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't find...
Thank you, Awakening, for becoming an uncivilian. Do appreciate it. Thank you for the gift memberships from...
I was simply trying to get it filed because the last day...
Thank you, Reyes-san, for the gift memberships. Do appreciate everyone who helps to support the channel.
Just gotten discovery.
It is only 99 cents.
We have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone and the information on phones. So we're diligently trying, number one, to review all the discovery, which still has not been done, at the same time trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD, I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was quite a bit of it, that she would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it, I wanted it as soon as possible. A short time later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday. I didn't have time. I knew this had to be filed. I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, Jorge Torres, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery in violating the conditions of bond relating to staying away from Sarah Boone. But battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client.
Sorry about the screen just going off there for a second. As you are privy to, I'm going to try to fix the audio. So I do have programs that designed to fix the audio to make it a little bit better. So I'm going to try to fix it as long as we're here. So we have it for the future, but I uninstall it because it seems to interfere with things sometimes. But I'm going to try to install it, and while we're, waiting. So hopefully we'll have it for the future. Also, I have to figure out how, I'm not even sure if it can deal with a mono source or not. We'll figure it out as we go, one step at a time.
In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape, please look at my phone, please look at the videotapes, please look at the photographs.
She was inviting the police to look at the things? Okay.
I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice that this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If in fact he finds somebody and they file something, to continue it, we'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we had filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres. I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances.
Okay, what did I do? And how do I unbreak it? This is why I shouldn't do things on the fly like this. But I try anyway.
The prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that...
It keeps freezing because I'm trying to fix the audio in the background to make it even better. I'm trying to wow you with my audio management because someone said that the audio wasn't good. And so I'm trying to wow you by making the audio like really, really good. And I'm changing some settings in my audio settings, and every time it does it, it interferes with things. But hopefully it'll be worth it in the near future. We'll find out together.
We had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate.
I haven't done it yet.
Our defense.
I haven't done it yet.
We've listed the
You don't need to be wowed yet. I haven't fixed it yet.
The last paragraph, paragraph 14 says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them, and when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic. And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand.
All right, I'm going to switch my audio sources and see if it magically makes everything better. Let's find out. Good. Could be exciting. Could be completely ineffective. We're going to find out together. Let's see. Properties, change this to this setting, do this thing. And if I turn this on, all right, and then I press play, will it work?
Understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state, and wherein our confusion lies, is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense.
What do we think? Was it worth it? I mean, it was kind of marginal, but was it worth it?
It is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome, and here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all of this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her
past violence against him and against Mr. Boone, it's hard to unring that bell. And even the King versus State of 2000, I forget which year, 19 case allows the state to point out the things that are promised in the defendant's opening statement and then don't come to fruition. That doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth? There's a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you. Judge
that's a choice.
Take the deposition of Dr. Oliver Timberwall, so they're going to know fairly quickly what our opinion is. What's your response to Wagner? Well, we're going to talk about Wagner, Judge. I don't want to talk about that, and he's blatantly arguing in the state's motion to strike my defendants a minute notice. And I would
like for Mr. Henderson to respond to what he said about that. But Judge,
Because I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang up that I'm having.
that's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
But that's not what Wagner stands for. Wagner didn't allow. Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Ultimately, the female defendant in that case claimed that the firearm discharged accidentally. And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right.
It cleaned up the audio a little bit. I mean, it made it a little bit better. I'm not sure if the juice was worth the squeeze or not, but we did clean up the audio a little bit. So yeah. I mean, there's only so much you can do, right? So yeah.
So how is battered?
It's premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the located battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Then what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused, and that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
It's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
Was that the overt act that caused the
But
death?
all of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at
I
Boston?
assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
I'm not taking away the court video. I'm not taking away any court video. I'm not taking away court video. There was that one moment when I had it on the wrong tab for just a second. But I haven't taken away any court video other than that moment where I pulled up the VAC page because I forgot about the tabs. I haven't taken away any court video. I'm trying very hard.
Hickman, the defendant, stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd 761, it was firearm. What's the
Mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement.
I don't
of particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. The judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brannon said on the issue of imminent threat, it is in the mind of the battered spouse woman.
Right there's the words. Imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I don't. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge,
words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The word self.
Yeah, I mean, I certainly agree with the judge that battered spouse doesn't make any sense if the defense is accident, right? Because battered spouse in principle is all about, basically I was driven, out of fear to defend myself because I was so afraid of the battery that I had to act for my safety of my own life. So intentionality is essential in the battered spouse. Like, I agree with the judge, like battered spouse and accident don't really make sense. And so the judge is confused. It's like, okay, is your defense accident or is your defense self-defense? And they're now saying, okay, it's self-defense, which is an interesting, that's a very bizarre self-defense theory. I think you're going to have a very difficult time getting a jury to buy this as self-defense. It's like, okay, he was such a threat to me, either imminently or as an ominous force that is a perpetual ominous force. He's such a threat to me that I put him in the suitcase out of self-defense. That's a rough self-defense case, man. That is rough. And so the judge is like, okay, are you saying this was accident or are you saying, so it's like, it can't be both intentional and unintentional. Yeah. Now, in federal law, you could probably try to technically argue both because federal law does allow for mutually inconsistent pleading, but you wouldn't really want to go to the jury with both. Florida may or may not allow for mutually inconsistent pleading. So it's like, you might have to pick one here. Like, yeah. So we're going to go with self-defense. I locked him in the suitcase in order to save myself. I did it on purpose. And to some degree, I'm glad I did because I saved my life. All right. Okay, that's a defense. Yeah.
Defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
Not accident, as they want to allege.
Well, no, I'm not sure necessarily that the prosecution wants it to be an accident. I would imagine the prosecution would be more than happy to work under the idea of, yes, she did it intentionally. So the defense's argument is, I did it intentionally. I'm pretty sure the prosecution would be more than happy to argue those lines too, because it kind of proves the essential elements of murder, right? I did it intentionally is an essential element of murder. And now all I've got left is justification. Okay. Yeah.
Does your compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us? If you can hear me, sir, you need to unmute.
Battered spouse syndrome has definitely come and gone from its heyday. Battered spouse syndrome is definitely not, even at its peak though. I mean, it wasn't like the end all be all, but its peak has long since come and gone. Yeah, I think you're going to have a really tough time with, I didn't stab him, I didn't shoot him, I locked him into a suitcase and let him suffocate. That's rough. And also the statements you made to the police under your interrogation don't really further that objective. Honestly, I think you're better off with accident, to be honest. If I'm trying to like game this out in the back of my head about what is the easier theory to prove, the accident seems better. Okay. All right. All right.
Yourself. I can, but I have some concerns because I'm getting reverb. You. I am, but it's my that we're hearing back again through your microphone. All right, this may work. Mr. Henderson, we'll give this a shot, sir. You can go ahead. I can, sir. Yes, sir, it is.
I'd like to respond. Well, I want to start here. But get the subject of the use of non-deadly force. Methods that do not require the notice have to come in, file, and say that I am relying on self-defense. The advantage is that if it's in the standard jury instructions, and before you can give that jury instruction, you have to have, and the cases were pretty clear, an indication or evidence, it's just in Satura evidence, that's what the cases say, to get the instruction.
I think we're just going to skip him because I can't understand anything. So we're just going to skip his argument. Let's just go ahead and save ourselves and skip. There's better.
Spouse syndrome is relevant to the subjective
Jesus Christ.
Belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I didn't know that would be raised today, but they kicked out PTSD testimony just last year, I believe it's in Okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. But that notwithstanding, it appears we're on the same page that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery and what left the state at a lapse in understanding this defense in particular was, did this violence cause her to suffer from battered spouse syndrome? And what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog. And then like everybody else, we were playing hide and seek. And he got into the suitcase and I accidentally went to sleep. And then she's shown her video. But her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not.
This is a fair point. This is a fair point. The state is basically arguing at this point that the defense can't make the defense, can't present the defense, because you have to have evidence, man. You got to have evidence. And like, what is it exactly? And where is it coming from? You know, is it coming from her? I mean, because if, you know, are you guaranteeing that she's going to be put on the stand? Because otherwise, where's this evidence coming from? State has a fair point, man. It's like, how are you? Yeah, state has a fair point. Good questions.
Made any statements about a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final positions rebutting, offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson?
Well, just, I'll let Mr. Henderson go, but just as it relates to Mr.
All you married couples in chat, saying, I've never played hide and seek with my husband. Maybe you guys are just missing out. Hide and seek is the thing to do, man. Woof.
Boone's testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir? You're muted. You will have to unmute yourself.
Trial.
Mr. Henderson, you're still muted, sir.
I don't want to hear from Mr. Anderson.
Trial.
Who's saying trial? That's not, who's that?
Trial.
Who's saying trial?
I'm sorry. Can you hear me now?
Loud and clear, sir. Any other additional?
Yeah.
Last is the
Trial.
defendant's motion for enlargement of time filed September 17th. Mr. Jay, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed
Trial.
that motion. Mr. Owens, you may proceed, sir.
Judge, and I do have about 2 or 3 other issues that we need to address, but I've asked for some time. I think there was an order, I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that
Trial.
you wanted some things for.
What the fuck is going on? Where is this coming from? Is it coming from me? Where is this audio coming from? Is it coming from me?
Trial.
Shut up!
Judge, of my defendant's motion for enlargement of time?
That says September 5 on paragraph 3.
Shut up!
Are you-
No one's allowed to say trial in chat. No one's allowed to mock Uncivil. Damn it!
You looking at my defendant's motion for enlargement of time?
Yes, sir. Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024. Am I looking at the wrong thing?
I'm sorry, I was looking at the wrong one. If you look at the second page.
Yes, sir.
Paragraph 7,
Yes.
that should be September 17.
Yeah, got it.
Okay.
I mean, obviously, the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late. Dr. Harbour formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall, is a critical witness in the case. We're trying to locate him. As you know, 4.5 years, people move, so we need more time, is my point. We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically, this rule 3.050, that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owen's trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once jeopardy has attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Any other final arguments, Mr. Owens?
No, sir.
Okay. I'm just rereading the rule. Give me a moment. Mr. Owens, as I stated when we had our hearing on September 3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case, and I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th. So I believe that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn?
Correct.
On that Monday, October 7th?
If we're lucky enough to get one on Monday.
So,
Just so that you understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case.
Judge,
So my intention is to run 50 people in the morning. So I'm just letting you all, full disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back, either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday. And we'll start whittling it down. And I can turn over, when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
is this set for 2 or 3 weeks?
2 weeks. 2 weeks. Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. If you think we need 3 weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later. Because in all candor, I don't know how long it's going to take us to get a jury.
I did not anticipate. I anticipated we were going to be able to pick a jury in one day.
Really? That's aggressive?
I would love to be that bullish. I hope we can. I'd love to be able to. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m.
You think you're going to find a jury in a day? That's aggressive. I do appreciate that you want jury selection to last a day and not, 8 months, like in the, some of those Georgia rapper trials that jury selection took 8 months, which I'd want to cause harm to myself long before 8 months. So but I appreciate that you're trying to get this done in a reasonable fashion. Yeah, that's nice.
I got 50 people teed up for 1:30, and that will continue throughout the week. It's easier for me to say, we don't need you, go home, you don't need to show up for jury service, than it is, I need bodies and we don't have them. Now, if we're able to get a jury in one day, fabulous. But if we can't, I have that backup.
I believe if we pick the jury in one day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay, all right. I'll see what I can do there, and I'll have Anita.
I am like just mentally cringing along with the judge at just the fact we're having this argument at this time. It's like, I don't even know what witnesses I'll discover. And the trial's supposed to happen October 7th. And I'm not sure what witnesses that exist and we're going to find between now and then. So Yeah, it's a little late in the tooth for that, but okay, that's what we're doing, I guess.
Report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago, trying to locate witnesses, it's just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that, I agree with the court, but I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions, sir?
There just may come a point in time, Judge, if you don't set a deadline, that the state has to ask for continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed
The
on.
fact that we have a deadline of witnesses on the 26th and we have trial starting on the 7th in a murder trial is blowing my mind. This is like the ultimate like procrastination nightmare. This is the ultimate I'm cramming for the test at the last minute. You know, the entire semester, I'm going to cram for it all in one night. Except it's not the entire semester. It's all 4 years of college. I haven't studied anything. I'm going to cram for it all the last minute. And I'll give you notice of my witnesses on the 26th for a trial that's going to start on the 7th. 10 full days, baby. 10 full days. This is amazing. This is amazing. Again, it's a murder trial. You know, it's not like it's a murder trial. So that kind of notice might be sufficient in some cases. It's a murder trial. That's kind of hilarious. Woof.
The record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Yes, I can, Your Honor.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the
Patient regarding the forensic psychologist, Dr. Harper, and the crime scene investigator, Dr. Birkeland. You had advised as the JACS's positions on those motions.
And we will not be hearing from that guy. And we'll not be hearing from that guy's testimony because I don't need potato mic, so skipping ahead.
September?
Yeah, is that not what I just said? I'm sorry if I did, said a different date. I will take it under advisement the issues pertaining to the battered spouse syndrome and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
This relates to the investigator, Billy Lane, who's working with the defense, and his potential costs up to the trial.
What does
So
the
the
S
hand file
mean
Now?
on the back of her uniform? I mean, it says Orange County Corrections. I mean, that part's easy enough because it's Orange County and it's corrections. What does the random S mean, do you think? What is the random S? I'm curious. You think it's size small? You think it's a size marker and it's on the outside? Yeah, okay, maybe. I don't know. Maybe it's unit number 5. I don't know. It looks like an estimate.
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll do that.
give these back to you, sir.
Judge, the other thing was, of course, we've got trial coming up quickly, and generally when
Also, when did prison uniforms come in a more discreet blue? I mean, that's just like a very sort of normal average color. Have prisons like gotten out of like colors that are more like, you know, bright red, bright green, bright, you know, orange, and more, we're going for a more sedate navy blue look? I mean, that could just be a t-shirt, man, to be honest. It's like, I don't know, as far as prison uniforms go, I don't know what's up with the blue.
in a courtroom, I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand here that we've got to be in front of a microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with court admin.
All right. And then the other thing is, we would like Sarah to wear street clothes. So do I need to file something?
I have, get in touch with the public defender's office. When Ms. Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Before you came on board, Mr. Owens, Barry Click, Barrieclick, had provided the total amount of clothing that they had that would fit Miss Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free rein and was going to have the shock device on her lower leg. I would ask that you can email Ms. Click. You can find her information on the Florida Bar webpage, and ask her if the public defender would assist you in provided clothing. They were going to while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. 1 is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
If you could get it to her.
Okay.
So that's something you have to work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, she would like for us to have some makeup for her and somebody to fix her hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Okay. I believe that's all I have, Judge.
Okay, all right. Anything else, State, we need to address? All right, anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay, I will see you all on September 26th at 9 o'clock in the morning, and I will endeavor to get you a ruling on the battered spouse issue as soon as practical, hopefully by tomorrow.
Thank you, Judge.
All right, thank you all very much. We're off the record.
I assume the ruling on the battered spouse issue is like whether or not the defense can present the defense or not. Or, yeah, because it's an interesting argument. So, very interesting stuff. So, first of all, the defense team got some wins. They got their experts that they wanted. So, all the experts they asked for, apparently they got, which is good for them. And, yeah. But not so much on continuations and not so much for their bill of particulars. But the defense had a good day today. The defense had a good day. They got everything that they got everything they had a chance of getting. So that was good. Someone to fix her hair and makeup, good luck. No, they'll get like something, right? They'll get something because they have a right to, have her appear in street clothes when the jury is hearing the case. And they have a right to like have her, have some minimal makeup to make her look presentable. So, they have a right to that. And they'll get some version of it. I'm pretty sure they'll get some version of it. They may not necessarily get a hairstylist or something like that, but they'll get some version of it or some ability to put her in a more, neutral light, so that'll be more favorable to the jury. So all that stuff. So makeup won't help. Probably not, but you know, they have a right to make her, you know, presentable, so it should be fine. So we can talk about some other stuff if you want, but that's the end of the hearing. So it looks like we're still on trial for the 7th. And yeah, that's basically the end of the hearing for today. Plus, you know, the judge is going to decide on the battered spouse stuff. So may deny the defense completely or may constrict it in some way. We'll see. Yeah, Diddy is not going anywhere. Diddy's not going anywhere. He's very much in custody, the statutory presumption, and he was not getting past that. So, yeah. And he's facing minimum of 15 years for his things. He's facing a minimum of 15. And realistically, probably more like 2025. And given that he's already in his mid-50s, you know, he's looking at, he may not see the outside of a jail again, depending on how things go. It's not going great for him. It's not going great for him, and it's not going great for R. Kelly. Neither of them are having a great time. So, yeah. Was Sarah ever offered a plea? I don't know. There wouldn't necessarily be a record of that if she was offered a plea. There wouldn't be a record of that. Plea conferences are typically confidential. In fact, you can't even use things that are discussed at a plea conference in trial because they're protected conversations. So maybe, but I don't know. Almost guarantee she was, yeah. And there may still be a plea deal on the table. You know, there may still be a plea deal on the table because you're trading certainty. Although at this point the state's got it pretty cold. You know, they're gonna play the tape of him begging for his life. They're gonna play at least some of the video of her confession. Maybe read some of the letters in open court. She's toast. So it's not going great. Nah, don't worry about it. We've been fine. You can go back and watch it. I didn't even know I was doing this either because originally my moderator said it was tomorrow, but it was today, which is fine because, you know, we can adapt to the times. Plus, my video I released today was basically tanking. And I'm not sure why exactly. This NCAA story I did very, very poorly. And it's like, I still to this day do not understand. I'm very, very bad at predicting what stories are going to be popular and whatnot. Like, because the story I did before that, you know, the video before the NFL or the NCAA story was about Sarah Palin in the New York Times. And I didn't think that was going to be particularly good, but it was my #1 performing video of my last 10. It did very, very well. I was really surprised. Like, wow, this video did really, really well. I was surprised. And then I did this video on the NCAA and I thought, oh, that'd be popular because, you know, sports and sports related things. And that video is tanking like an absolute stone. It's tanking like a complete stone. So I can't figure I can't figure these things out for the life of me. You know, Sarah Palin sues the New York Times. I mean, you know, he gets 20,000 people watching that video. You know, NCAA and issues relating to that gets like no one watching the video. I don't understand these things. It makes no sense to me. Incidentally, of course, I need to actually record more. So I think I'm going to do another live immediately following this, or at least close to it. I might take a very short break, but I'm going to do another live. In fact, I'm going to go ahead and schedule it because I need to do some recording for some new stuff that I need to do. We are doing a recording today. Let me find out because I don't remember what I wrote because my memory is like a goldfish these days. Let's see. Oh, I have one on Mr. Beast because he got sued. So I'm doing a follow-up story on Mr. Beast getting sued. And then I have a story about the DOJ going after the people that were behind that ship that hit that bridge in Maryland. So the DOJ is suing for $100 million. So I'm going to cover the ship hits bridge story and Mr. Beast getting sued by contestants story. People who like law stuff usually aren't sports fanatics. So we're going to record those two stories. YouTube had recommended Sarah Palin. Did I fix the audio setting? Oh, did I fix the setting? I did not. I did not fix the setting. Thank you for reminding me. See, one of my mods reminded me of something. Or no, it wasn't even my mod. Eddie, my non-mod, reminded me of something. Thank you, Eddie. A pot of spaghetti? That sounds nice. The bridge thing wasn't a couple years ago. The bridge thing was like 6 months ago, tops. The bridge thing was not that long ago. The bridge thing was like, yeah, it like basically just happened. Yeah, that thing, yeah, that didn't go well. You could always do a poll, but then I need to ask people. I need to know what to ask them to vote for. And yeah. Yeah, bridge thing was this year. Yeah, it was very recently. It was incredibly recently. But the DOJ just filed a lawsuit against them. And they're alleging that the owners knew and about problems with the ship and didn't care. And so I got a script on that. End of March? That sounds right. Yeah. The Pokemon thing with the, yeah, I was thinking about the Pal World thing. I don't know, that's a bit of a difficult story to write, but I might try it. With the patent thing. I might try to cover it, but I haven't written a script for that. Maybe tomorrow. I'll try writing a script for it. I tend to believe the DOJ. The DOJ has a very positive reputation to me. You know, the DOJ does not mess around. And they tend to be able to prove exactly what they say. That doesn't mean they're right every single time. There definitely been cases like with the Michael Flynn thing where I'm like, the DOJ's wrong. But, you know, the DOJ's reputation is intact. So like when they file something, they get my attention. Because it's like they are usually bang on the money. Correct. It's one thing the federal government is really, really good at being lawyers thing. They are really, really good at being lawyers. So they've got that going for them. What am I trying to do? I'm trying to schedule a premiere for myself. And then refer myself to myself. You're out? Oh, no. All right, I'm going to schedule this for 3:10 so I can use, well, I'll schedule this for 3:10 so I can take a quick stretch break. So, schedule this for 7 minutes from now. Okay. Does being a lawyer for the government pay well? Not particularly. But it's very prestigious in a lot of ways and can open up other opportunities. All right, let's see. Redirect to myself. Save the redirect. Okay, guys, I'm going to end the stream. I'll see you in about 5 minutes for members. If you'd like to watch my content where we do recording sessions and editing sessions, it's members only. So you have to be a member. So now would be a really, really good time to hit that beautiful, beautiful join button and become a member. So you get your name in green, you get a cool little scale of justice by your name, you get some cool emojis, and you get access to behind the scenes content, such as the editing and recording sessions that we do, which is fun and exciting. And you like that kind of stuff. I know you do. So you should hit the beautiful, beautiful join button, and then you can be part of that and, all the rest of it. Yeah. Yeah, the Top Gear Grand Tour thing. I was thinking about posting that as a excerpt. I might still do it because the video today was doing so poorly. I might post that separately. In fact, I might do it while we're on stream because I already have it edited down. So all I have to do is actually post it. And the video today didn't do any well, so I might as well. So I'm going to go ahead and sign off, and I will see you in about 5 minutes or so. Hope you